Good afternoon and welcome, students, ladies and gentlemen. Today, the 28th of May, 2020, Asian Law College, under the aegis of Asian Education Group, is proud and delighted to host the very distinguished Justice Dr. Arjan K. Sikri to this live webinar on Constitution and Constitutionalism. Justice Dr. Arjan K. Sikri, a prominent judge of the Supreme Court of India, known for his diligence and hard work, has delivered over 900 judgments. He has served as the Chief Justice of the Punjab and Haryana High Court and retired from the Supreme Court in 2019. Presently, he is an international judge at the Singapore International Commercial Court, SICC, Singapore Supreme Court, where he was sworn in on the 2nd of August 2019 by the President of Singapore. He is also the chairperson of News Broadcasting Standards Authority. Few of his landmark judgments include the Aadhaar verdict, green fireworks manufacturing, Article 136 amendment to cut down the number of cases pending in Supreme Court by half. Also, as Chief Justice, he has issued notice to Ministry of External Affairs of India taking cognizance of a public interest litigation application seeking the release of 2 prisoners from Punjab languishing in Pakistan jails even after completion of their sentence. He had also issued directions to the states of Punjab and Haryana and Chandigarh administration on what remedial measures to take to curb the menace of crime against women. He has been chosen as one of the 50 most influential persons in intellectual property in the world in a survey conducted by Managing Intellectual Property Association, MIPA, for 2007. Justice Sikri, sir, Asian Law College welcomes you to this webinar.
Thank you. So thank you very much, the ALC team, for inviting me on this webinar, and all the students who are participating. Let me at the outset say that yes, these COVID conditions through which we are going, these are difficult times, no doubt about it. And we have to overcome these difficulties, which I'm sure would happen after some time. And in the present in lockdown situation, when everybody is confined to homes, of course, with partial lockdown, you young students can still roam about, but a person of my age is not permitted to go out even now. But when the colleges are closed and you are spending time on these webinars in such a constructive and educated manner, this is our best way of utilizing the time. So I congratulate you all who are attending today's lecture or who have attended other lectures organized by ALC, and wish you good luck in your future endeavors also. Coming to the topic, which is Constitution and Constitutionalism. Let me at the outset itself structure my thoughts as to how I'm going to develop the theme of Constitution and Constitutionalism. As you can see, and you know it, in as far as Constitution is concerned, what it is all about. At least every law student has idea about what the Constitution is. The Constitution is an instrument which is the instrument of governance of a country. It can be an instrument of governance of a club also, some society also. But we are talking here in the context of a nation. But then once the Constitution is there, how it is different from constitutionalism? And what are the attributes of a constitutionalism which have to be there in order to make a constitution a viable document? That is the idea of today's discussion. So what I propose to do is since the constitution in the context of a nation state, we are talking about the governance, why even the constitution has become necessary. If we trace the history of mankind and at what time the nation states came to be formed and why it became necessary to have a constitution which would govern the a particular nation. So that would be my endeavor. Then telling you that the document itself, which is the constitution, may not be sufficient because constitution can be in any form. You may be having in your mind perception of Indian constitution, but that may be only one type of constitution. But there may be other kinds of constitution also. But there are certain essential attributes for for better governance of a country, which are called constitutionalism. And what are those aspects, and what are those precepts, or what are those inherent qualities, attributes, which should be in a constitutionalism to make a constitution a viable document? And then I would turn to the scheme in very brief about the Indian constitution and how the objectives of this constitutionalism can be achieved in any democracy and how we have endeavored to do that. So that is the scope of my discussion today. Now, as I said, talking of nation states, if you know, till recent, I mean, times, say a few thousand years ago, in the man was not had not settled at one place. Originally, we were all nomads. Our forefathers, our ancestors, they would go from one place to other. About 10,000 years ago, with the advent of agriculture, and when they started, because before that they were only hunters. So they started um, rehabilitating at certain places, normally near the rivers, etc., so that they can get the water for agriculture purposes. And there it started that some kind of, I mean, congregation of some people, they are at one place. But then, how to regulate them? Maybe it is a society in a loose form which is created, but how to regulate them? There was no such regulation, nothing even at that time. So this is called a situation which we normally say a jungle raj or might is right. So anybody, if I am a mighty person, I could deprive another person who has taken some land and is having his agriculture. So I could deprive him of that, and I could myself go there and confiscate his land, etc., or even his crops. And so there was no rules, there was no mechanism how to regulate the society. So naturally, what was there in such a society? Insecurity and dominance of a mighty person over a weak person, and that too physically, not mentally. Now, but then at the same time, human nature and is okay, let me tell you at this stage. So this kind of situation where everybody is insecure from the other person, Thomas Hobbes, who gave us the theory of social contract, he describes this as a war situation. Here, it's not war, W-A-R, but W-A-R-R-E, war situation. And so therefore, he says that in this war situation, it is the insecurity and dominance which prevails, and that there are murders which would take place very often, and therefore the life expectancy would be very, very low, because nobody knows at what age he will die at the hands of some other person. And but at the same time, he said that, look, what is the human nature? Human nature, the basic human nature is to be peaceful. On the one hand, disputes do arise in any society at any place among the people. like in modern society, we resolve those disputes through courts by a proper system. But in those days, when there is no society, nothing, but people are together, so disputes would arise between them. But at the same time, the human desire is that to have some basic amenities, some economic opportunities, and to live in peace. And this gave rise to, according to him, that how to await such a situation. He said that, look, over a period of time, if you see the history, the uh, instead of giving power to everybody and anybody, people thought that why we should not come together and give power to one person who would govern us. But then it is only one person who would govern us. And this is what he calls a Leviathan state. It is in his book. The name of the book is also Leviathan, which he describes as commonwealth or a nation state. So this is how nation states started coming, building. And but what he says is that, look, this there were two routes of creating these nation states. One was through confiscation, where one person would come, confiscate, conquer, and start ruling. This is, if you know, happened even from this 1000 AD to almost up to 1947, when we got independence, when the people from other countries came from time to time and they conquered this country and they were the rulers. So that is one way. But then they governed the society, and during this period only we had one of the greatest kings as well, which is known because two greatest kings in Indian history which are known are, in the ancient time, Ashoka, and in this time which I am saying is Akbar. So that is one way. But the other way is this commonwealth creating by the people for themselves through institution. Here he is talking of institution giving to a person or a group of persons whom these people choose, and that they give, that you take it. Now what happens in this, this is if I tell you this, he calls social contract theory, that there is a social contract by the society. People have entered into a contract that we will join together and give the power to this person or these group of person who would rule us. It can be monarchy, it can be even dictatorship. But then he said that, look, at least even if it is monarchy, one person is there. It is not that every person is against every person and the power is given to one person. Now, there was one flaw in this theory, which was this: although he said that it can be given in the hands of one person who may turn out to be despotic, but then it is better to have one person rather than giving authority to everybody and anybody. Everybody is enemy of the other person. But then over a period of time, many social thinkers or political thinkers, they improved upon this theory, and the way it happened, and in particularly last 300-400 years, was this: they said that, look, in even in order to see that the person who is ruling his subjects, there should be a what we call rule of recognition. There should be some rule of recognition, that we recognize his power. And therefore it is not necessary that this rule of recognition to an institution should be only people. It can be another and any other institution also which is not human being. Of course it would be governed through human beings only, but the institution may be something else. So therefore, without dilating much on that, because much is written about Leviathan and there are so many improvements thereon and so many criticism of that theory also. But then what was said, and particularly by Hart, you in your jurisprudence you will read that, look, what we can do is that in order to ensure that it is not a despotic state, that institutions which are created should be governed by a set of rules of recognition, and so that they are governing within the framework of that. This gave rise to the modern democracy. And the starting point, if we say, was French Revolution. Because before that, it was monarchy, king was there. People, he didn't even know, I mean, how his subjects were, I mean, sexuality, etc. And there were hardly any governance in that, which led to French Revolution. And right of man were recognized there, in which we say that dignity as well. Now, thereafter, and within a few years thereafter, when America became independent and it came out with that constitution, all the states were got together and they said that, look, what we are talking, instead of man, what the heart had said, it should be institutions. So institution is the people who select these people or elect these people by a democratic way. Those would be the parliamentarians, as we know today. Then the majority party, which gets the I mean majority vote, would be entitled to form the government, which would be the executive. And then there has to be some independent branch, that is judiciary. So this is how it is conceived, the three institutions for a better democracy. And even these three institutions, two more aspects were there. Number one, separation of powers, that each wing or each limb of the state would work within its own spheres, which are described in the constitution. As I come to our constitution state in brief, I will let you know that. And so therefore it is separation of powers, but then they are also not supposed to exceed the power which is given by that instrument, that is the constitution, which is the rule of recognition, recognize. So constitution in that sense becomes a rule of recognition, and this is the document within which the three organs, they function and they administer the governance. So this is how democratic states came into being, with constitution. But at the same time, the constitution, it is not necessary that constitution has to be a written constitution. There may be constitutional values, all these aspects which are there of separation of powers, etc., which has happened like in England over a period of time. uh, there was, if you know, the fight between the church and the king, because it was monarchy, it is still a monarchy system, is still there. But then over a period of time, through common law also, uh, uh, so many features of constitution were created by the people, which were accepted by the society and were enforced through common law by the courts also. So we have unwritten constitution of America, of England, but then it has all those features which are necessary for a constitution. But then modern democracies, mostly all of them have written constitution, which started with, as I said, America and other countries which they followed. Now, what happens in this manner, if I say in short, that the constitution is a document which is the document of the governance of a nation, as I said. It is the highest form of the law in a country. And every other law, because if the parliament, while making the law, that, as I said, legislature, while making the law, is supposed to adhere to the principles of the constitution and to have to act within the frame, so it cannot enact a law which is contrary to any provision of the constitution. So that is there. And then, as I said, checks and balances, that the three institutions, there are checks, and on which I come little later, which are there. So therefore, but at the same time, there are in various countries, various kinds of constitution may be there. Even a dictator who is or a monarch may still come out with the constitution, and they will say that these are the constitutions, or these are the provisions under which I will work, or the people, various institutions created by a monarch or a dictator will work. But we are talking of a constitution of a democracy. Now here, the fundamental, as I said, social contract theory is that there are people are choosing their representative who will govern them. So that is why, if you see Indian constitution, like American constitution, starts with the word "we the people." If you see the preamble of the constitution, it says, "We the people, having resolved such and such, such and such, give ourselves this constitution on this day, So therefore, it is the people of the nation who have given themselves, and it is the people of the nation through electoral method. They elect the persons who have to govern, who have to form the government and govern. In that sense, power in the sovereign, we say, are the people, but the sovereignty for time being assigned to the elected representatives, but those elected representatives have to come back to the people again and again, like in India, after every 5 years, and seek the mandate again. They can be thrown out if the people are not happy, and therefore it is a form of democratic constitution. Now, as I said, this gives one thing, I mean, rise to one thing, that it is the majority which rules. But whether that is sufficient for any constitution? So answer is not. And here they say that attributes of a good constitution, in any good constitution for better governance of a society, should be there in a constitution. And these principles are called constitutionalism. And if I say in this sense that let me here say one thing which is very important. When even Hobbes mentioned the theory of social contract, and why people should come together, and why they should not fight, and why it should be given to one person, at the bedrock of the social contract theory is the liberty, that the people should remain liberal. They should have their choice what they want to do, of course within the framework of law, and not that without any reason, etc., their freedom is taken away. So therefore, liberty remains the bedrock. So it becomes the first attribute of a constitutionalism, that any good constitution have to have the provisions of liberty of the people, which has to be recognized on the principle of dignity. That is choice given to the persons the way they want to live. I want to become an advocate, it is my choice. I then choose to go as a judge, it is my choice. Or anybody can do anything. That is the based on the principle of dignity and freedom. So therefore, this aspect has to be there in any constitution. Then the second thing is that, as I said, there are three wings of the state: legislature, judiciary, and executive. This has to be a necessary attribute of a good constitution, which is separation of power, because all power should not be in one person or one institution. Like monarch, if you know, the kings used to, in their darbars, used to decide cases also. So they were having judicial power as well. But here it is stated that it should be in different hands. And that judicial power, not only there, the judicial power, it should be a different institution. Certain institutions should be independent, which we call independence of judiciary. That independence and autonomous, it should not be influenced by the other two institutions, that is the legislature and the executive. So essential attributes are therefore this liberty, which along with that comes all human rights, and then dignity, then separation of powers, independence of judiciary. And when we say that even elected representatives have to work as per law, then the supreme position which is given to something is the law. That is, we call rule of law. So it's a society which is to be governed by rule of law, in the sense that all laws are to be obeyed by everybody. As it is said, howsoever mighty you are, law is above you. Whether it is prime minister of the country, or a peon in any organization, or a housewife, they're all subjected to law, which are made, and the highest law, the constitution. These attributes have to be there in a constitution, which are called attributes of constitutionalism. And this gives rise to one thing. If you see, there's very important thing. I mean, all that, how it is to be secured. This call it when we give these rights, we call it the concept of limited government. That government, in that sense, is limited by its power, which are stated there in these documents, and which are essential for good governance. But then another aspect, actually, at the same time, these aspects are also called, which I have told you, all these attributes. If I may say so, in one Barnett, in his book called Constitutional and Administrative Law, he has stated 4 attributes of constitutionalism. A, he says that the exercise of power be within the legal limits conferred by Parliament on those with power. That is the concept of intra vires, and that those who exercise the power are accountable to law. This is where we call rule of law, and intra vires means they cannot act beyond their powers which are assigned to them in law. Second, the exercise of power, irrespective of legal authority, must conform to the notions of respect for the individual and the individual citizenship rights. This is we call human rights, or which are based on the concept of liberty, that social contract theory propounded by Thomas Hobbes. Then third, that the power conferred on institutions within a state, whether legislative, executive, or judicial, be sufficiently dispersed between the various institutions so as to avoid the abuse of power, which I said, 3 institution and separation of powers. Then the fourth is that the government, in formulating uh, policy, and the legislature in legislating that policy, is accountable to the electorate, that is the people on whose trust power is held, that we say where people are sovereign and they have to elect the representative after every 4 or 5 years. Now, this is all to ensure even the elected representative. And another very important aspect of constitutionalism here is protecting the rights of minority, also in any ethnic rights of minority, religious rights of minority, and even in the democratic setup, those that parties who are in minority, in that sense, not only of the people, and they're also like in parliament, when the opposition, which is in minority, sits, how their rights are also protected, their right to speech and every other thing. So that is what the all the important facets of constitutionalism are there. But then, as I said, that it is to avoid exercise of arbitrary power or despotism by any state. These are called in recent times. Now, up to now, these were treated as the attributes of constitutionalism, which are, as I said, are in our constitution. All these this scheme provides. We have, if you see our constitution, it talks of 3 organs: legislature, executive, and we have federal system. So union is there, the chapter on that. Then state legislature is there. Then we have union executive, and we have judiciary at the Supreme Court, as well as the high courts and subordinate courts, which are there. And uh, the judiciary is given that, and the doctrine of it. We work on the doctrine of separation of powers. We have chapter on fundamental rights as well. But then, is this the complete facet or complete a picture of the constitutionalism? Answer is no. This is what the recent in last few years, 30 or 40 years, some jurists have said that these are the attributes of a negative constitutionalism. That is where you check the arbitrary power. They are necessary. Check the arbitrary power of the state. You ensure that the people live with freedom, and in order to that is done, the judiciary is given the power of judicial review, which enforces the law. And if any act done by the parliament or the even the executive is wrong, it can invalidate any law passed also, and any act of the executive also, that decision is against the principles of some constitution or some law. So therefore, this is the scheme of Indian constitution as well. But at the same time, as I was saying, jurists have said that, look, this is not the only purpose of constitutionalism. When we also framed the constitution, we said it has to be a welfare state. welfare which should work for the benefit of downtrodden as well, which would work for the marginalized persons of the society, the poor, which should, I mean, it should work in a way that we achieve economic progress. So it is what I call it good governance in one sense, that where the power is not misused, and here the good in the sense where the standard of living of the people and their rights are enhanced. So therefore, these are also the attributes of a constitutionalism which are known as social welfare, solidarity, economic equality, that is egalitarianism, etc., and social justice. So these are now known as positive constitutionalism. So we have both negative constitutionalism, which is essential, but at the same time, positive constitutionalism is also required, which is again essential for the progress of any nation. And the people who are elected and they exercise their power, the persons who have elected, the citizens who have elected, expect from them that they should take the country to a better economic progress, road of economic progress. And that is why, if you know, the at the time of elections also, many political parties, they will come with their manifestos, that if they are elected, they tell the people that what we are going to do for the betterment of the people. But these provisions are contained in the constitutions as well. In Indian constitution, we have directive principles of state policy. That entire chapter says how the what is expected of the government, how it should work, and all those principles which are stated there are the aspects of positive constitutionalism. Now in this whole process, this is the constitutional the negative and positive constitutionalism. What is important at this stage is that, let me tell you very frankly, I'm trying to compress this as I mean, because the time is 35, 40, 45 minutes. Otherwise, constitution itself, the students know, there are commentaries which are written in thousands of pages. Likewise, there are many books on constitutionalism also. So but then my endeavor is to compress it, so therefore give you an idea about what the constitution and constitutionalism is and how it is achieved. So now I am coming to how it is achieved. You see, it is very good to have these in the constitution. It is very good to have a democratic system where the people elect and people are sovereign. But for day to day, I mean, people are sovereign in the sense that they will elect their representatives. But then all this also has to be done in accordance with the norms prescribed in the constitution. In that sense, constitution becomes the sovereign instrument. It is the constitution is the sovereign in that sense. Now, how it is to be achieved? In Indian constitution, which we have borrowed from American constitution, that concept, it is by, as I said, which is the attribute of constitutionalism as well, independence of judiciary. Now, the three functions which are assigned to three different pillars of the state: parliament or the legislature makes the law, executive, which is the government of the day, which executes those law, make policies, etc., and implement those policies for the progress of the country and for the governance of the country, and judiciary, which enforces these laws. So the function of the judiciary here, normally in day-to-day sense or common sense, and a commoner would think that whenever a dispute arises between two parties, naturally he will go to or she will go to the court and the court has to decide that. But this is a myopic view of the function of the judiciary. The judiciary has to perform much larger function. As I said, whenever, if there is any law which is passed which is unconstitutional or contrary to provision of constitution, it is depriving any person of his fundamental rights, his right to do business, his freedom of speech, etc., his right to travel, then that law can be declared unconstitutional. This power is given to the Indian judiciary by the Indian constitution. That is power of which we call power of judicial review. And this is two kinds of powers. That is judicial review of legislative action. That even if the law is passed, that is subject to review by the judiciary whether the law is validly passed or not. This power is not in England with the judiciary. Any law which is passed by England is not subject to scrutiny at all. But this power is, as I said, in many countries it is there, including India and America. And the other power, which we call judicial review of administrative action or executive action, which you read in administrative law. That is, the court can decide a particular policy decision taken or particular action taken against anybody, whether it conforms to law or limits of law. It is done within that. If it is not, the judiciary has power to again invalidate such an action. So therefore, the attributes of constitutionalism are enforced by the judiciary, and that is the function which the judiciary has to have and judiciary has to exercise. Now, why, in spite of constitution, I told you when there no constitution, etc., how the society is governed, and it is might, right, or jungle raj, etc. But we have seen, history has seen, even with constitutions, dictatorships have come. Take the example of Hitler. He was elected in those times. Take the example of Mussolini in Italy. He was also elected representative. And in our India itself, remember emergency days. Even when at that time Indira Gandhi was elected prime minister, her party was in power as majority, but only after her election was set aside as unconstitutional, which again is the power with if even the election is not fair, the court can strike down such an election. And when it was done, she wanted, instead of stepping out and going again back to the people for mandate that you elect me again, she took another route. She said, no, I will still govern, and almost assumed dictatorship by declaring emergency. So all this happens even when the constitutions are there. But then here, responsibility of the judiciary comes. And therefore, I say, apart from deciding the cases on day-to-day basis, judiciary has to perform two basic roles in order to achieve negative constitutionalism and in order to achieve positive constitutionalism, the attributes which I have said. First role is to protect the democracy and the constitution, which is, I said, all the attributes of negative constitution. Whenever there is a threat to the democracy, even by those who are governing, elected representatives, and whenever there is a threat to rule of law, it is the court which has to decide those cases and uphold that rule of law. And second main function of the judiciary is to bridge the gap between the law and the society. Where, if you see in Indian context, how many judgments which are given for developing the sphere of human rights law, the cases where this PIL jurisdiction itself, creation of that, so that the marginalized section of the society is able to get justice, access to justice, and their rights are protected. And the another because all these are subject to, if I start discussing that, each aspect needs one full lecture. But then how it is achieved, the courts in India, many of the because if you know it, directive principles are not justiciable. If a government doesn't adhere to some directive principle, the other person cannot come to the court and say that you should direct the government to do that, because that is not justiciable. Whereas fundamental rights, that is justiciable. If somebody commits a breach, you have a right to come to the court. But what a novel process which is adopted by Indian judiciary is that many directive principles, maybe in that chapter, are read as fundamental human rights in article, by interpreting article 19, article 21, article 14, etc., as I said, on which there can be a detailed discussion how it has been achieved. But on that basis, the court has been giving directions from time to time. Take, for example, today that case which is going on. Of course, I'm not going into this aspect that why Supreme Court woke up so late about the migrant laborers during COVID times. Now, giving them wages, fair wages, etc., giving employment are all provisions contained in directive principles. But then those are brought into the human rights by interpreting Article 21 widely. That right to life and liberty doesn't mean only animal existence. It means right to live life with dignity. And therefore, right to food has also been interpreted as part of Article 21, and it should be given their judgments on that. And therefore, this today the Supreme Court can take note of that and can direct about the plight of migrant workers. Otherwise, the government could simply say that, look, it is a matter of policy, but what we do, what we don't do. But then no, it is their fundamental rights, right to live with dignity, and that is why it becomes a violation of Article 21. That is one example I wanted. Now, how the Supreme Court has achieved this constitutionalism over a period of time, let me tell you again in brief, because each aspect which I am telling you again calls for a detailed discussion. One is, we have Article 368 of the Constitution, which says the Parliament has power to amend the Constitution. Now, amending power is there, and if it is some provision of the, I mean, that some provisions can be with 2/3 majority, some provision with 3/4 majority. So there may be a situation, there are situations many times where 2/3 majority is there. There may be a situation where even 3/4 majority is there. But suppose some government comes in power, and that Parliament at that time with such a majority wants to amend the Constitution and take away the entire chapter of fundamental right is abolished. It can do so theoretically. Now, in order to see that democratic constitution and constitutionalism remains, I mean, this is the most celebrated case which the Supreme Court decided, what we know Keshwananda Bharati case, where the court laid down basic features of the Constitution. It is not written in the Constitution. Basic features of the Constitution which are unamendable. Even the Parliament and all the judges sit, MPs sit and decide such thing, it will not happen. And what are the features of basic features of the Constitution? Democracy itself is the basic feature of the Constitution. Independence of judiciary is the basic feature of the Constitution. Separation of powers is the basic feature of the Constitution. So therefore, tomorrow it cannot be amended that entire power, even the judicial power, will be given to the legislatures. And so therefore, right to life is the basic feature of the Constitution. So therefore, such powers which were given, such features which are in the Constitution are treated as basic features of the, with the, I mean, direction or with the holding that the Parliament has no power. That is why even when this NJAC Act was passed, that giving power to the executive to appoint the judges, again, I'm not going into the whether the judgment is right or wrong. That may be again a subject matter of controversy or discussion. But then the court invalidated that legislation, and that was one legislation where every parliamentarian wanted, and it was passed in I think few minutes in the Parliament, because everybody wanted that, the government wants that they should have some right to appoint the judges. So therefore, but still the court invalidated it, saying that it violates the doctrine of independence of judiciary, which is the basic feature decided in Keshwananda Bharati. So the limit, Article 368, the power to amend the laws or even the Constitution is limited by adhering to or by protecting the constitutionalism and democracy. And all the, if you see by this judgment, all constitutionalism which I said stand protected. Now, what are the other methods which are adopted? As you know, ultimately at the end of the day, even if a law is passed by the Parliament or the state legislature, when it comes to the court is the final interpreter. And therefore, sometimes by way of interpretation, they will say some rights which are affected, no, it will be read down like this, it will be read down like this, and so that the rights are not affected. Or there are another concept which is used, is that which we call silences of constitution, that there are some aspects of a constitution which are not there in black and white, which we take from even common law also, which are, because there is no written constitution, as I said, in Britain, but then they have to be read into it. Basic features is again an example of silences of constitution which are read into them. Another thing, if you know, in later many judgments, Supreme Court, it started with Manoj Ralula in 2014, and then in government of NCT versus Union of India, and then in Puttu Swamy, the 9 judgment, this 5 judgment thereafter, also in privacy judgment, they talked about constitutional morality. Now, there is something inner morality, as Lon Fuller, a great jurist, has also said. In all these constitutions, there is some inner morality of a constitution. And those, all these precepts are those of the inner morality. And therefore, that by even if some right is to be created in the interest of the nation, in the interest of the society, the principle of inner morality or the principle of constitutional morality are brought in. And another aspect which I say, although that again it is not in the constitution, it is only in preamble, one time it is used. It is not even in fundamental rights, the word dignity. Dignity again is treated as something which is silence of the constitution, but it is there in the constitution. Because how the Supreme Court has read over a period of time, and there are now so many judgments on that. I have written few judgments, I have written few articles also. But what I am trying to say is that as Article 21, I said that right to live life is right to live life with dignity. Now, word dignity was not there. Article 21 only says nobody shall be deprived of his right to life and liberty except by process of law. But how much expansion to that particular article is given by using the word dignity. Therefore, right to food comes. Therefore, right to environment comes. Therefore, right to sleep comes. Therefore, right to live, sleep, and there should not be any noise, etc., and loudspeakers in the evening, etc. All those judgments are there. So they are all the rights of disabled persons, rights of women, that judgment of sexual harassment at workplace. Now, all these are based on this is based on the dignity of women. So dignity is read into these judgments, and on that basis, the this constitutionalism is upheld by the courts in various judgments. And another aspect, which another tool which is adopted by the Supreme Court recently, of course, it was there earlier also, but expanded a lot. First, it was in that NEET case, uh, where the 5 judge bench overruled earlier judgment of NEET and said that NEET is possible and it is valid on the principle of proportionality. And then it came in with much force in the judgment in Puttu Swamy privacy cases, where the court, how you have to, when you deal with invasion into the human rights, because if you know Article 19 uh, talks of certain freedoms, but then all freedoms are not absolute. Article 19 subclause 2 to 6, they talk of reasonable restrictions also. Article 14 also talks of reasonable classification. But then in order to test that a particular restriction which is imposed, or there is a reasonable classification, the rule of proportionality is pressed into. And rule of proportionality says what? The thing should be proportion. That first of all, we have to see whether a particular right claimed by a person is a fundamental right, like right to privacy. The dispute arose in Puttur Swamy whether it is fundamental right at all or not. If it is, then the second question is whether any limitation is imposed by the concerned law on that, because limitation can be only by law. If it is by administrative action, it will be set aside there and then. But even if there is a law, then third is whether it is proportional, whether the inroad into that right is minimal, and whatever is required in order to achieve the objective. So these are the test of proportionality, how the proportionality test is applied. So these are different tools which have been employed by the courts from time to time in order to uphold the constitutional values. Of course, I would only say with one rider, or rather two comments. At times, court has failed. One was emergency itself, ADM Jabalpur case, where the preventive detention, etc., were there. Although all 9 high courts decided, they quashed those preventive detention, but the Supreme Court in ADM Jabalpur said that no, during emergency, when this emergency is imposed, even human rights or fundamental right chapter is also suspended, which was, of course, taken care of, and ultimately even that judgment in Puttaswamy stands formally overruled, which was given by one of the judges was Senior Justice Chandrachud, and his son Justice Ananda Chandrachud has overruled that judgment. That is one aspect. Other is the judicial activism. There is a criticism some at times that look, by assuming all these powers, the court is now have taken the power of governance of the country also, and that way it is infringing the principle of separation of powers. It is interfering with the policy matters, etc. And again, that is again a topic of wide discussion. But what I say at the end, in order to achieve the constitutionalism, activism of a judge is necessary. There is a difference between judicial activism and judicial overreach. Judge should not indulge into overreach and cross the Lakshman Rekha by trampling into the powers which is left with the executive or which is with the parliament. But activist judiciary is necessary in a country like India, not only to protect the fundamental rights, not only to protect the citizens against arbitrary power of the state, and but also in order to see that the government functions in the interest of people, that welfare state with the positive constitutionalism I said. So that is, in short, is my discourse on the constitution and constitutionalism.
So that was a wonderful cascade of information, and I'm sure everybody's realizing that. And we have hordes of students here who have so many questions. I don't know whether you'll be able to take all the questions today. But then we could begin with these and with some short answers for all of them, sir. So kindly name a particular provision which you feel is best in the Indian Constitution and which has enabled you to deliver justice to people at large.
No, please repeat the question again.
So I said, if you could name a particular provision which you feel is best in the Indian Constitution and which has enabled you to deliver justice to people at large.
I tell you one thing which I say, the provision. First, I will have to say two provisions, or rather three provisions, but they are interlinked with each other, which I have even indicated in my lecture as well. Article 14 and 21, of course, along with Article 19, but primary Article 21, right to life and liberty, because right to life, the way it is expanded, if you go, I'm telling the students should see any book on the Constitution and Article 20. Normal, when you read this one line or two lines article in one sentence, that, as I said, nobody shall be deprived of his life and liberty except by process of law. It doesn't even say due process of law. Now, that means one would get an impression, that means I have not to be deprived of my life. That means nobody can take away my life or liberty. That means nobody can take away my freedom and put me to jail except by process of law. That means if I committed some crime, if it has to be given in a myopic sense, it is this article to be seen. If I have to committed some crime, unless I am held guilty, I cannot be deprived of my liberty and I cannot be deprived of my life, because punishment can be from, taking away liberty up to death, depending upon the crime.
Okay.
But Article 21 is not read in that sense.
Okay.
And what I say is, which is not there in this article, which I just now said, dignity, which is read into this article. And that's why I said, if you law students go to any book on constitution and read the commentary of article 21, there are at least, as I said, right to food, right to sleep, etc., and right to move around. There are 40 rights which are created under article 21. 40 rights, 39 or 40 rights. Somebody, I think once, Attorney General of India, Mr. K.K. Venugopal, he counted and told us in our constitution bench judgment when I was also there, he was criticizing the activism of the, because he was appearing on behalf of the government, criticizing the activism of the judiciary, says, look, Article 21, and you will keep on creating more and more rights. But what I am saying is, which has inspired me also, and I have written a lot on in my judgments, I am saying, I've written articles as well, that the main fulcrum of expanding the human rights jurisdiction is this word dignity, and how every human right contained in chapter 3 can be traced to dignity. I've written my article also. If you want, I'll send that article. You can circulate it to you. I had given one speech. It was some memorial lecture I had given on that. And it is expanded and expanded, I mean, further and further. That is what I say. Another thing which is, which I have indicated is, I said that they are all interconnected, is giving power to Indian judiciary, the power of judicial review of the legislative act also. That ensures us that the all the limbs of the state, executive, parliament, even judiciary, they work within their limits.
Right, sir. So we have Ishanya Gangwar from LLB waiting in the wings. Ishanya.
She is not audible.
Good
Yes, sir.
afternoon, sir.
Good afternoon.
Am I audible?
Yes,
Hello.
now you are. Yeah,
Yes,
Good
yeah.
afternoon, sir. So my question to you is, hate speech does not serve any purpose in a democracy. So what can be the parameters as the rise of extremism is inevitable if hate speech is legally protected? Thank you, sir.
No, but hate speech is not legally protected. You see, it has to be viewed from different angle. Of course, you are very right in saying that hate speech doesn't serve any purpose. Here, we have a, I mean, Article 19(1)(a), freedom of speech is there. But this freedom of speech is not absolute. That and if you read Article 19(2), it says that it is subject to I mean the other rights of others, like I mean, by exercising your right to speech, you can't defame somebody else, can have libelous remarks, I can't abuse somebody, or I can't act against the state, that is sedition, etc., all those, or I can't indulge in obscenity, right to speech is there. So these are all mentioned in Article 19(1)(2). So therefore, depending upon the contents of a particular speech, which is hate speech, whether it is coming in the four corners of any of these restrictions, if it is, or then depending on this Article 19(2), laws are also there. We have Section 292 of the IPC, which says that, which is against obscenity. We have this Section 499 and 500 of IPC, which talk of defamation. They are all laws protected by Clause 2 of Article 19. Otherwise, but for Article 2, all these laws would have been invalidated. And freedom of speech means absolute freedom of speech. So therefore, if hate speech, depending upon the contents, if by that hate speech you are infringing the religious values of somebody, which may be offensive of Article 25 or 29 or 30, or you are defaming somebody, which may be infringement, which may be defamatory or libelous, and there may be the civil action also, the criminal action is also there, or as I said that you are saying something which is obscene, then law of obscenity comes. So it should come within the, so depending upon the contents of that hate speech, it will have to be seen as to whether this becomes any offense or anything which is not to be permitted. On social, I mean, if you see and as a good citizens, yes, and when we are in I mean, and that is also the message of Indian Constitution, brotherhood, then hate speeches are not good things. No, there's no doubt about it.
So Mahima Sharma, are you there?
Yes, ma'am. Good afternoon, sir.
Good afternoon.
So my question is, the President of India, according to our constitution, is given all executive powers. But in reality, when we see his role is very limited in the country's governance. Sir, what is your opinion on this?
No, I don't know in what sense you are asking for opinion. You see, in our parliamentary democracy, one thing is very clear. He is given he is the head of the executive, but he is a tutelar head. Even the constitution says he has the power is to be exercised with the aid and advice of the council of ministers. So therefore, it is the it is the government which is the elected government, and they form that council of ministers with the prime minister as the head. So therefore, he has to act on that advice, and on that basis when he has to act, and his role is limited. But then there are many judgments. Some Singh case, you just go and read that judgment of 1978 by Justice Krishna Iyer, which discusses in detail these aspects. And because this is in our constitutional itself, the provision is that it is the council of ministers who have to act day-to-day act. Of course, titular head is the president. So therefore, if you know the acts are passed, everything, it is the president who signs. But then in the constitution itself, or that has been interpreted by the Supreme Court also in various, there are certain circumstances or certain situations come when he has to act at his own discretion and not at the advice. Because suppose tomorrow it comes whether the government in power, whether it enjoys majority or not, it has lost majority, suppose, and the opposition says that it has lost the majority and some action is to be taken, and they go to the president. At that time, president has to not go to the same council of minister and say, what you want me to do? But they will say naturally in their own interest, no, you save us. So therefore, there are many situations in the constitution which are stated, and where he has to act on his discretion, but generally on the aid and advice of the council of minister, and that is the scheme of the constitution.
So we have Abhishek Gambhir from LLB 6th year.
Good afternoon, sir.
Good afternoon.
Sir, my question is in techno-legal field. As a matter of fact, technology is highly disruptive in nature, while law follows due process before being enacted. So, sir, in that case, is our judicial system well equipped and ready to address issues like determining rights and liabilities of those machines that are creating patentable inventions?
And this is a question in totally different context. You see, as you know, technology is coming today at a much faster pace.
Yes.
And it outweighs or outsmarts the legal system. Today, in order to take care of some aspects of the technology, if you make some law, tomorrow the technology would there would be another kind of technology, and let me tell you, it's very interesting. I've forgotten the name of that person who has said, and very rightly, if you see that industrialization which started about in late 17th century or 18th century, this period remained for more than 200 years. the progress, technological progress or other, that was not made in those 200 years, which was made in first 10 years of 21st century. And today, because we call it from, there was agriculture economy, industrial economy, and today it is knowledge-based economy. And in knowledge-based economy, a knowledge-based word, every minute, every second, there is an advancement. And I don't know how the law can cope with this. So therefore, there are two ways only to deal with it. Number one, existing laws, how these are to be interpreted by the courts in order to take care of the situations which even develop later on, but bring within the provisions of that. But that is the interpretative process. But then still there may be certain situations where law doesn't answer. So this is a gap in law which the court cannot fill. Court can interpret it, and but then if there's a gap, then that court cannot interpret. For that, it is only legislature who has to come, and these are those situations.
Yes. Thank you,
So Simranpreet Kaur.
Good afternoon, sir. So my question to you is that, sir, do you think the current rise in crime of mob lynching has been adopted by general masses as a medium to express their anger against the government? And how can we curb this inhuman act, sir?
You see, there are not only mob lynching, so many other things which are happening in a democracy. Uh, First thing which I would say is that, look, it is again, as I said, one thing which I hinted was minority rights also. I'm talking of this lynching in from two angles. One is that where sometimes some people who are in minority are subjected to this kind of cruelty. Other is there are those who are criminals, like that happened in Andhra Pradesh few months ago, that the persons who were, I mean, we find that there, of course, it was, they were, uh, I mean, killed by the police in police encounter, saying that they wanted to run away, etc. But then when we find that whenever some of these criminals, when they are found, then they are caught by the mob. Mob tries to kill them. So there are two ways of looking at it. Insofar as first category is concerned, of that kind of mob lynching, where majority wants to suppress the minority. I'm not talking of majority in any sense. It depends on area to area, which I mean communities in majority, which is not so. But then it depends upon the good administration on the one hand, that it is the administration which has to come with iron hand, and the judiciary has to support by giving very severe punishments, and send a message to the community at large that it is not I mean tolerated. And insofar as other aspect is concerned, which I have said, again, the this is that exhibits rather the anguish of the people, that look, law is not able to, suppose somebody is accused of committing rape, then they, and that is what happened in those, that Andhra Pradesh case about 3-4 months ago. So so therefore, or maybe 5-6 months ago. So therefore, in such cases, it is the law reforms which have to come, and it is because people should not take law into their hands. And ultimately, at the end of the day, above all, the answer is the society has to be civilized. We need, therefore, so many kinds of reforms, educating the people. Education is one very, very important thing. People, even as in the rape cases, etc., it is said that, look, uh, the mothers in their houses or sisters in their houses they should tell their men folks or brothers and children, etc., that, look, what is the dignity of women, and we are here in this house, and you should respect it, and you should not go out and treat other women in another manner. So it starts, so therefore social values, education, etc., all these are also needed. So it has to be a bouquet comprising of all these aspects, which will take care of these aspects.
Justice, sir, we'd like to take you back to your student days. What has been the role of your law teachers and classroom education, sir, in your journey, which is dotted with commendable achievements?
No, I tell you very frankly, much of this, what I have been able to achieve, whatever little, credit goes to my teachers in my law faculty. Those were the days. Number one, because I am a product of Delhi University law faculty there. Delhi University law faculty was almost, because there were no these 5 years law courses, no the private schools like your universities, etc. So there were not many law colleges in the country. Every university would have one faculty or some law colleges, etc., like Bombay Law College. But then our law faculty at that time used to be treated as the best in the country. It was because of the experience and brilliance of the teachers. I tell you, even today, you name those teachers and since you belong to this teaching community, and name those, they all, if you see, most of them, 80 or 90% of them, you will relate it to Delhi University. Professor Bakshi, who is today is still there, Professor MP Singh, Professor Nigam, Professor, if remember, I know many you may not be here, may have heard those names. Professor Shiva Remaiya on those days, Professor Aradi, Professor Singh, there was one, Professor Nigam. Now they were world-renowned teachers who had their respect all over the world. They used to go a lot. We have seen outside and teach there as well. They used to be invited. 2/3 of the faculty which had done their PhD, etc., were from other universities from the world. So with this kind of talent, and the atmosphere was also good. Well, let me, another thing very important, which is very, contrast with the present day is that though in those days, law was not that cherished subject. People used to say, it is the last resort. I remember one of our teachers, he used to joke us, this joke with us, and we would crack that joke, saying that students come here not to do law, but to find their in-laws. So that law student not serious. If they are not able to get admission anywhere else, they will get admission in law. Whereas today it is total contrast. The law is a subject not only which is demanded by the student, it's a matter of choice. They want to go into that. And so they compete very hard. That today's students are much more studious. But therefore, in our law faculty, say I was from the morning center, which is called Campus Law Center. If there were 500 students, there may not be more than 100, or even less than 100 who were serious. Others were not serious. Whereas today it may be out of 500, 450 students would be serious. But those 100 students which were serious, and the kind of education they got. If I tell you one thing today, even today, there are 9 judges in the Supreme Court who are from Delhi University. 9 judges in the Supreme Court. This is after my retirement, after retirement of Justice Gogoi, who was also from there, after retirement of Justice Madan Lokar in last few months. So even today there are 9 judges. And recently one judge retired, Justice Deepak Gupta. He was also from Delhi University. So therefore teachers played a big role. I mean, they in our constitution law, the way they, I would say, we imbibe from them the cherished values of freedom, rule of law, etc., which I am talking. And with this passion, then we started practicing. With this passion, I did. I started. Discharged my duties as judge.
Just one more, sir. Ananya, are you there?
Yes, ma'am.
Yes.
I'm there.
What's your question?
Good afternoon, sir.
Good afternoon.
So my question is, Article 15, Clause 3 of our Constitution lays down for making special provisions for development of women and children. Still, we find them to be most vulnerable to the crime in this society. How can we overcome this, sir? Thank you so much.
No, you see, again, okay, at least I am audible.
Yes, sir, you are.
So I'll give the answer. No, what actually Section 15(3), it is an enabling provision, Article 15(3). So it ensures that it should be, so anything which is done contrary to that would be naturally it's unconstitutional. But what topic you are raising, many of these rights, even today, if you see, when 1/3 of our, or at least 30% of our people are still living below poverty line, when many are still illiterate, and today, as I earlier also said, the position of the migrant laborers, etc. Now, there are so many other causes, and it is the good governance coupled with uh, a society, a civil society, which is responsible, which can not only force the government to act in the interest of all these, but so all these factors are required to bring change. The change cannot be brought only by law and enforcement of law. These are all the aspects of social change. So social change, the bringing about the social change requires so many other players to act in tandem, and we need a robust social society, the civil society, which should be responsible civil society. First, we have to see within ourselves, and we know all about the fundamental rights chapter. There is one fundamental duty, Article 51A also. So all this is required to bring about these changes.
So before I just wrap this up, I would request you to leave a message for the students of Asian Law College, sir.
I would only say, look, I tell you very interestingly, I was reading just few days ago, it came on WhatsApp, Obama's remarks to 2020's high school graduates. And what he says is that because in this COVID situation, etc., he says that, look, this pandemic has finally torn back the curtain on the idea that so many of the folks in charge know what they are doing. You are, now he's addressing the young students, you are going to have to grow up faster than some generations, the way we did. And he has said that three things which you should keep in mind. One, don't be afraid that we have come out of these things, we will come out. And but he says that in your life also, you have to work like that. Secondly, you think right. You think what is right. And here he says that you decide to ground yourself in values that last, like honesty, hard work, responsibility, fairness, generosity, respect for others. And thirdly, because today's time, COVID times are also now teaching us, it is, although we are in a social distancing, at the same time, the way, we are trying to help others, the way philanthropic values have been now, they are evolving in us. When we see the way we are contributing to the PM fund, or we are giving ration, etc., to the others, we are trying to help. Entire community is coming forward to help. So therefore, my message is that work hard, be always, honest, and it is ultimately that honesty which will pay you. Honesty and hard work.
Yes, sir.
Thank you.
Thank you, sir.